Report progress. Good morning, everyone, and welcome. Today, we will explore one of the most important pillars of our national identity. It is the Philippine Constitution. As you know, our Constitution is more than just a legal document. It is a testament to our shared values, aspirations, and the principles that shape our society. So as we delve into its provision, we will look at the vision of our premiers and for the Philippines now how these principles continue to guide our country in an ever-changing world. Thank you for joining, and I'm excited to have this opportunity to learn and reflect on the essence of our Constitution together. So we will start on what is a constitution. A constitution is the fundamental and supreme law of the land. It establishes the framework for the organization of the government. As you can see, it also defines the powers and duties and outlines the rights of the people. In short, it is the source of authority from which all laws and executive action must derive their legality and legitimacy. So, as a basic fundamental documents of the land, these will lay down the structure of the organization, the government, and also its powers and duties. And on the other side, the outlines the basic rights of the people. So that is the Constitution. So in a nutshell, based on the case of Lambino versus Comelec, the High Court said that there are elements of the Constitution. First, the Constitution of Government, which establishes the basic structure of the government, branches, and their operations. So as we know, our branches of government, we have the legislative, the executive, and the judiciary. That is the three branches of government, and their operation varies based on the power vested to them by the Constitution. Next is the Constitution of Liberty. It states the fundamental rights of the people, which is enshrined in Article 3 or the Bill of Rights. The Bill of Rights. Okay. Next is the Constitution of Sovereignty. It provides how the Constitution may be changed because it is a constitution by the people, for the people, hence the people can change that constitution. It is also enshrined in a written constitution, the sovereignty. So that is the elements of the constitution. Now, let's go first before we proceed on understanding on how the Constitution being interpreted. There are three. First, the verba lies, which means whenever possible, the words used in the Constitution must be given their ordinary meaning, except where technical terms are employed. It highlights that the Constitution, even though it is essential to the rule of law, is not primarily a lawyer's document. uh, and must be understood by the average person in order to be ever present in the people's consciousness. So this was crafted for easy understanding of the ordinary Filipino people. Uh, that's why the plain meaning rule, the verbal is. Next is the ratio is anima. It in cases of ambiguity, the words of the Constitution should be interpreted in accordance with the intent of the framers. It stresses that the doubtful provision must be examined in the light of the history of the times and the condition and circumstances under which the Constitution was framed. Lastly, the Aut Mages Valiat Quam Pariat, which means that the Constitution should be interpreted as a whole. This means that certain provision should not be taken by themselves, especially in order to favor specific objectives, but rather interpreted together with all other provision, meaning it should be interpreted as a whole, not just piece by piece or portion of the said constitution. It should be interpreted and connected to the general or the whole document. That is the third interpretation of the Constitution. Now let's go back to the history. Prior to the 1987 Constitution, the Philippines has uh, crafted different constitution in different times that serve the needs of its people. First, the Malolos Convention, which was uh, approved and ratified on 1899. It's also known as the Constitution of the First Philippine Republic. That is the First Philippine Republic in Malolos, Bulacan. It was the fundamental law of the Philippines during the short-lived First Philippine Republic. Prior to this, now we learn from the history that there are already various efforts conducted by our forebears. Prior to this, there was Cartilla. Cartilla, which embodies the ideas of our people. The Sangguniang Hukuman, and which precursor, no, the Republic of Biak na Bato, no, Republic of Biak na Bato, and also the constitutional provision de la Republica Filipinas, which was the ultimate, the Malolos constitution that was approved by the Malolos Congress on January 1898. However, this constitution was quite short-lived. It's just a symbolic. It's actual, no? Because as we know that the Spanish-American War in 1899 was ended, and Philippines was ceded to U.S. By the Spain under the Treaty of Paris. So we are ceded to the U.S. through the Treaty of Paris. So in the times of American colonial period, there were efforts, no? There were efforts to craft uh, the documents which will came out as a constitution. There was the institution of Second Philippine Commission in the 1900, and then the Philippine Bill of 1902, uh, uh, Philippine Bill 1902, and then the Philippine Autonomy Act of 1914. So these were the initial effort that culminates in the drafting of the Tidings-McDuffie law, McDuffie, which was approved by the U.S. President then, President Franklin Roosevelt, on 1934. No, Roosevelt approved this law on 1934, which paved the way for the crafting of the 1935 Constitution. This Constitution established the Commonwealth of the Philippines, which served as a transitional government before full independence from the United States, which happens in 1940s. So this constitution also provided the framework for the 1973 constitution. So it provides a framework. This 1935 constitution was drafted and ratified by a majority vote, no, in the plebiscite that was held on May 1935. You can imagine the votes, majority votes, the time is 96%. So you can see the longing of the Filipino people to become an independent nation. Okay, so in 1946, we have the independence from the American, which is the result of the Commonwealth, is 10 years transition to independence. Thus, in 1946, we have the independence from the U.S. Okay, during 1960s, there are efforts. As I've said, 1935 Constitution is the framework. Hence, in the 1960s period, there are efforts to draft a new constitution, and it culminates in 1971. 1971, there was an election, for the Constitutional Convention delegates. No? There was this Constitutional Convention delegates are tasked or were tasked to draft a constitution. However, the Constitutional Convention, it did not finish yet their task to draft a constitution. Marcos declared martial law. As what we have learned, some of the delegates, like the late Chipisto Gogola Jr., was arrested, and others went to exile, and other worked with the government. So there are different happenings, the time, and the martial law. But in 1973, Marcos conducted or called for a plebiscite. However, it was not pushed through due to his fear that the plebiscite will result in a no vote. Thus, he canceled the first plebiscite, and in lieu of that, he called for a citizens' assembly. And every area, Metro Manila and other countries, and there are two questions. If the voter ratifying the Constitution, and second, if there is a need for a plebiscite. So the answer for the ratification is yes, and the answer for the necessity for plebiscite is no. Thus, Marcos declared that the ratification by citizens' assemblies on the 1973 Constitution was approved on January 1973. Okay, so that is the 1973 Constitution. It was a product of martial law era under President Ferdinand Marcos, and this replaces the 1935 Constitution. So it now shifts to presidential form of government with a parliamentary system. However, in 1976, Marcos asked for some amendment for the Constitution, and since then, he exercises legislative power. So in that amendment, there is a power provided to Marcos, legislative power. So thus, the martial law during the Marcos era prolonged until 1986. 1986 came the EDSA revolution. The EDSA. We have the EDSA, the peaceful revolution. And Cory came into power in defiance of the 1973 Constitution. Okay? So, after a month of assumption to the office on March 1986, Cory enacted the 1986 Freedom Constitution after the ousting of President Marcos. This provisional constitution was promulgated by then President Corazon Aquino, and it served as an interim constitution until a new one could be ratified. Here in the provisional constitution, it also mandates the appointment of constitutional commission, CONCOM, which was tasked, to draft a new constitution. So that's why in 1987 we came up with a new constitution, and it was ratified on February 2, 1987. So the 1987 Constitution replaces the 1973 Constitution. It reestablished the presidential system, the government, and introduced various reforms to safeguard democracy and human rights, including the structure, no, the formulation of three branches of the government. We will discuss later on the detail of the 1987 Constitution and how it differ with the 1986 or 1973 Constitution, the martial law. So that's the evolution or the history of Philippine Constitution, which is now the current constitution that we have. Okay. Next, we will proceed with that. No, from the history we can learn basic concept, no, basic lessons learned, and how it will guide us in our future uh, task, no, guide our people in crafting their future. First, the Constitution supremacy. It says that the Constitution is supreme, meaning it takes precedence over all other laws, policies, and governmental acts. Any law or executive act that is inconsistent with the Constitution is void. Uh, this principle of constitutional supremacy is enshrined in Article 2, Section 1 of the 1987 Constitution, which states that sovereignty resides in the people and all government authority emanates from them. So this is a big uh, pronouncement or declaration of the new constitution that sovereignty resides in the people. And it clearly shows that all government authority emanates, no, from them, from the people. Under Article 8, Section 5 to A, the Supreme Court has the power of judicial review. This is a different provision which is not or found, which is not found in the previous constitution. And judicial power of judicial review allows to declare acts of the government, such as the laws, executive orders, or even treaties, as unconstitutional. Also, you can see the supremacy of the Constitution and the rule of the Supreme Court and the rule of the people, because sovereignty resides in the people and all government authority emanates from them. Okay? Next, as we can observe in the history, there are various methods or modes on how to amend and revise the Constitution. Under Article 17 of the 1987 Constitution, it provides for the amendments or revision. When we talk about amendment, it refers to a specific unlimited change, meaning quantitative change. While revision implies a more comprehensive or substantial alteration, substantial alteration. So if you change the essence of presidential into unit parliamentary, and then from uh, the the power emanates from the people to other power which is dictated by dictator, you are changing the essence, you are revising the constitution. So here the constitution may be amended or revised by first Congress As we have observed in the history, Malolos Convention that was approved by a Congress, and then there are appointed Constitutional Convention, and there are also elected. 1971 Constitutional Convention, they were elected. During Cory, they were appointed during the times of Cory. Constitutional Convention, the delegates, they are appointed. And now the fourth or the third boot of changing the Constitution is through People's Initiative. This is absent in the previous Constitution, which now the people have a voice. They have the power to change or amend the Constitution. If the Congress do not want to change or uh, revise or amend the Constitution, the people has the power through People's Initiative. However, there are requirements. There should be a petition signed by at least 20% of the total registered voters nationwide. Second, there are at least 3% voters in every legislative district. Uh, so that is the requirement for People's Initiative. Okay? So there are various efforts, like what Marcos did, the citizens' assemblies. However, there are questions that even the Supreme Court were divided or was divided during the martial years. No? If they are, they will, the Citizens Assembly that ratifies the Constitution is valid or not. Huh? They were divided in 1973. The case of Abiliana versus Executive Secretary. Now let's proceed to the basic elements of a state. These are enshrined on the various international covenants that to become a state, there should be the four elements. First, the territory, which is a definite territory with people and others. So the population is the inhabitants. It's either citizens and then aliens, no, the sojourns. And also the government, which is a political organization of the state. And lastly, there should be a sovereignty or the absolute right to govern within a particular territory. So these are the elements, the elements of a state. So in these four elements, our discussion will emanates from these four elements, no? The territory, population, government, and sovereignty. But before that, no, the basic elements, we need to discuss first the basic concept, in constitution. First, as we have said, no, territory, uh, in a broad stroke, we have the archipelago, Philippine archipelago, enshrined in our constitution. Then we also have the aerial, fluvial, and maritime, and terrestrial, which is the land. So these are the territory, no? The whole of the archipelago, and then including the aerial, the fluvial, and terrestrial, and the waters around, no? And uh, the inland waters, the inland waters. Uh, so these are included in the territory, Philippine territory. We will discuss it more in another uh, video, another uh, module. No? So next, population. Uh, the state should have a population where the inhabitants, no, it's either the citizens, no, it's citizens who are the Filipinos, and it is stated, no, who are the Filipinos, uh, the natural born, and then the naturalized, the different mode of acquiring citizenship, no, and then we also have the aliens, no, those who are sojourning in the Philippines. No? So they are the inhabitants or the population of the states. Next is the government. No? Here, the citizen, we will discuss further. No? The citizens have the right to vote, to exercise, the right to suffrage, and also the right to be voted. No? To be voted. And also to be appointed. After the elected official, they have the power to appoint, to different branches or part of the government offices. Okay, so that is the inhabitant, the citizen, and the aliens. No? We also have the foundlings, no? The foundlings which was declared by the Supreme Court as part of the citizen of the country. Third is the government. No? The government, as what we have said, there are three branches of the government, that is legislative, executive, and judiciary. So this is the three branches of government. And also the Constitutional Commission, uh, the COA, COMELEC, and the Civil Service Commission. It also mandates the creation of the Commission on Human Rights and other uh, part, no, of the government structure. The Commission on Human Rights and other non-commission uh, agency of the government. Lastly, we have the sovereignty. Sovereignty it says absolute right to govern within a particular territory. Huh? As we have learned, sovereignty, uh, we have the national territory where we exercise our sovereignty. We also exercise sovereignty in our population through the inherent power of the state. No? This, on the other hand, this inherent power of the state has limitations. No? The limitations, which is the Bill of Rights of the people or the population. Bill of Rights. We will discuss it further. And then another one, the principle or doctrine of sovereign immunity. Immunity, which says that the state cannot be sued uh, without its consent. Okay, so that is the sovereignty. And then we also have the declaration of principles, oration of principles of our constitution. Uh, the different principle enshrined in Article 2 and the and okay. So we will be discussing those topics in the future. And the other one, the basic concept, no, the concept on uh, separation of powers, no, separation of powers, the check and balances here in the government, no, check and balances, separation of powers, and then delegation of powers. We will be discussing it here today. And then the other one, the territory will be discussed in the next video, and also the population and uh, the citizenship. Okay, so also in sovereignty, as we have learned, there are external and internal. Uh, so the sovereign governments should be uh, in external, no? It has a relation with the other states, no, other countries, with the president as the chief architect, no? It's chief architect of international relation or foreign relation. Okay, so those were the topics that we will be discussing in this video and in the preceding videos that we will upload. Now let's move forward in the basic concept. The basic concept first, as what we have said, there are three branches of government. That is the legislative, the executive, and the judicial. The legislative branch has the power to propose, enact, and amend and repeal laws. No, it's about the crafting of laws. No, on the other side, the executive branch has the power to enforce or implement laws. No, the execution of those laws that was enacted or amended or repealed by the legislative. And then the judicial branch has a judicial power to apply or interpret the laws. No, there might be misinterpretation or correct application. Then the judiciary will interpret such laws if it is constitutional. No, so you can see how important the constitution in the separation of powers. No? In every branch, they have an exclusive jurisdiction. No? Legislative, executive, and judicial. No? They cannot interfere because of the separation of powers. No? There are interference from another. Here comes the judiciary through the Supreme Court in interpreting the laws, no? And then conduct a judicial review of the implementation or the application of such laws if it's aligned with the Constitution. Now, in different jurisprudence, we can read now that the separation of powers is a fundamental principle in Philippine system of government. It obtains not through express provision, but by actual division in the Constitution. Its department, the executive, legislative, and judiciary, department of the government is exclusive cognizance of matter within its jurisdiction, and is supreme with its own sphere. No? So here, the three branches, no? The legislative, executive, and judiciary. So they have the uh, exclusive cognizance, no? Of matters within its jurisdiction, and they are supreme within its own sphere. No? Judiciary, the executive, and the legislative, they are supreme within their spheres. No? So that is the separation of powers. Also, it is the duty of the judicial department to say what the law is. No? What the law is. Where necessary, courts expound and interpret the rule or the law. If two laws conflict with each other, the court must decide on the operation of each if courts are to regard the Constitution. And the Constitution is superior to any ordinary act. That's what we have discussed in the constitutional supremacy. The Constitution and not such ordinary act must govern the case to which they both apply. This is the case of Marbury versus Madison as early as 1803. The court cannot interfere with or question the wisdom of the conduct of foreign relation by the executive department. So as we have said, the chief architect of international relation is the president. So accordingly, the court cannot direct the executive department either by writ of certiorari or injunction to conduct our foreign relation with Japan in a certain manner. This is in line with Binoy et al. Versus Secretary Romulo. Next is the court said that soon as the General Appropriation Act is approved, this is a law, Congress cannot have any post enactment participation, because that is an execution of the law, the General Appropriation Act. It was thus an error for the members of Congress to request allocation of funds from the office of the president to implement projects in their congressional district. This is the decision of the Supreme Court in Belgica et al. Versus Ochoa. So you can see the separation of powers among the branches of government. So this is to ensure that democracy at work, which we cannot found in the 1973 Constitution during the martial law. Next, the check and balance. So that is a separation of power, but this is interrelated. The check and balance. Check and balance is a system that allows each branch of government to amend or veto of another branch as to prevent any one branch from exerting too much power. There are overreach, there are overlapping of other branch with the exclusive jurisdiction or exclusive power of that branch. There should be a check and balance. It is important to have a check and balance. Examples: the Congress voting separately by a vote of at least a majority of all the members in regular or special session may revoke such proclamation or suspension as the case may be. They have the power to revoke such proclamation or suspension. That is the Congress in relation with executive. Here, the Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of habeas corpus, proclamation of martial law or the writ of habeas corpus. The Supreme Court must promulgate its decision within 30 days from the date of filing of the petition. This is stated in the Lagman versus Villaldia in relation to the Marawi Seas. No? Number three, the President may exercise veto powers on laws enacted by Congress. Thus, in signing of laws crafted by the legislature, subject for the signature of the President. The President may veto the whole law or portion of it, the part of it, he can veto. The Supreme Court also may exercise the power of judicial review to determine if there has been grave of abuse of discretion, a branch of government or instrumentality. No? So you can observe the check and balances, one branch to each other. No? They have the check and balances, not to overbreadth, not to encroach with the jurisdiction or the powers of the said department or branch. Now, we also have the delegation of powers. No? Delegation of powers is the act whereby a political authority invested with certain powers turns over the exercise of those powers in full or in part to another authority. The principle of delegata potestas, non potest delegare, means that all the powers of the branches of the government are merely delegated to them by the people. So they enjoy these powers as delegated duty. So they cannot delegate the responsibility of carrying out the delegated task to some other agency without violating the delegation. That is the general rule. The general rules that delegated delegation of power is not allowed. No, it's not allowed. However, there are exceptions. Non-delegation rule, the general. This is the general rule. The powers vested in each branch are considered non-delegable, which means they cannot be transferred or delegated to another body or agency. Each branch is expected to exercise its powers exclusively. No? As I said, this is the legislative, this is the executive, and this is the judiciary. So the powers vested in each one is non-delegable. That is the general principle. However, it cannot be delegated to others, and that one, its branch is expected to exercise its power sa iyalang branch, in his branch. Reason for non-delegation is to maintain check and balances, prevent abuse of authority, and ensure that the entity constitutionally assigned to exercise a power remains accountable for the people. They are both accountable to the people. So each one of them are accountable to the people. So to remain or to ensure that the said entity, the said branch of government exercise the powers. They have the accountability to the people. Exceptions. The exceptions to the principle of non-delegation are the following. Delegation to local governments of the power to enact ordinances. That is the power of the Sangguniang and the city or Panlalawigan. Delegation to the President under the Constitution of the emergency power, and the determination of tariff rates that is exempted or exception to the general rule of non-delegation. And lastly, the power of the people under the concepts of referendum and initiative. That is the power as what we have discussed. Sovereignty resides with the people. So they have the power, no? Of the in terms of referendum and initiative. Test for valid delegation of power, legislative power. There are two: the completeness test and the sufficient standard test. The law must be complete when it leaves the legislature such that it contains all the essential elements or standards for implementation. It should clearly indicate the policy to be followed, the purpose to be achieved, and the limitations of authority delegated. That is the completeness test. So there's no room for leaves the legislature that contain ambiguities or it should be executed. No more discretion on the part of delegated authority. Sufficient standard test, there must be adequate guidelines. There must be adequate guidelines and limitations. You have already outlined the framework of the implementation of such delegated power so that it is clear where are the boundaries and that will guide the delegate on how the authority is to be exercised to prevent arbitrariness or abuse. So you have defined already the boundaries, the limitations. And thus there are less, less arbitrariness or less abuse or eradication of abuse. Next is the sovereign power, sovereignty. Sovereignty, Section 1 states that the Philippines is a democratic and republican state, and the sovereignty resides in the people. And Reagan versus Commissioner of Internal Revenue described the sovereign prerogatives of a state within its territory. Nothing is clear settled than the Philippines being independent and sovereign. Its authority may be exercised over its entire domain. There is no portion thereof that is beyond its power. Within its limits, its decrees are supreme. Its commands paramount. Its laws govern therein, and everyone to whom it applies must submit to its terms. That is the extent of its jurisdiction, both territorial and personal. Necessarily, likewise, it has to be conclusive. If it were not thus, there is a diminution of sovereignty. That is the sovereignty of a state in a given territorial unit. This is in line with the case of Reagan versus Commissioner of Internal Revenue. Next is the concept of state immunity. State immunity, it says that the Constitution declares that the state may not be sued without its consent. So the word is may. So this provision is merely a recognition of the sovereign character of the state and an express affirmation of the unwritten rule insulating it from the jurisdiction of the courts of justice. So without its consent, it cannot be sued. So the consent of the state to be sued be given expressly. As the wording is may, So it can be sued or it cannot be without its consent. So when should the consent be given impliedly or expressly? No? There is an express consent when there is a law expressly granting, no? Granting authority to sue the state or any of its agencies. There is an implied consent when the state enters into a private contract. Well, this is implied. Unless the contract is merely incidental to the performance of a governmental function, as in the case of Santos versus Santos. And two, when the state enters into an operation, that essentially business operation. Unless that business operation is merely incidental to the performance of a governmental function, like for example, janitorial services, which provide services within the embassy. That is incidental, no? Incidental to the performance of a government function. In this case, the instance of arrest service. No? So, third, when a state issues a private property, no? When there is, example, expropriation. Unless the suit is entered into only to resist a claim. No? If the government expropriate, they have to file a complaint for expropriation. That's the time that implied consent for the state to be sued. So there are two acts, no? In relation to state immunity. First is the public acts, or what we call the jure imperi. This is the doctrine applies to acts that are purely governmental or sovereign in nature. This include legislative, executive, and judicial functions such as enforcing laws, diplomatic activities, military decisions, or regulation of public services. Next is the private acts or the jure gestiones. The immunity does not extend to the state's commercial or proprietary activities. When the government enters into commercial contracts or transactions typically reserved for private individuals or corporations, such as trade or business contracts. So here it may be held liable. That is the implied consent for the state to be sued. Okay? So here, the doctrine of non-suitability suitability of state is available also to foreign states, no? Not only the government, but also the foreign states. No? They may not be sued in the local courts because they have sovereign immunity. No? The added basis in this case is the principle of sovereign equality of state, under which one state cannot assert jurisdiction over another in violation of the maxim par in parem, non habet imperium. So that is the states are equal. Huh? So to do so, what actually makes the peace of nation. So that is the sovereign immunity of states. So that's it for today. We will be continuing the discussion on other topics in the preceding videos. Thank you for watching and listening for this video. And I hope you have learned. And we will continue discussing the different parts of the Constitution and other laws that are related to our daily lives at our country as well. Thank you and good morning, everyone.